Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is December 12th, 2018. The time is 9:31, it looks like now. With me today are Commissioner Emily Lindley and Ms. Tracy Gross for the General Counsel's Office. I'm John Neerman, and Ms. Gross, I'll ask you to begin the proceedings.
Good morning. Item number 1 is the Senate Bill 709, House Bill 801, hearing a request involving the application of Vulcan Construction Materials LLC for new air quality permit number 1473920L001. We have several individuals that have signed in. We have Lawrence Bailey with State Representative Kyle Biederman's office, who is available if the commission has questions. We also have several individuals who have signed in to speak. However, by letter dated 11/7/2018, the commissioners indicated that they would not take oral argument on this matter or additional comment. So we will note your presence for the record, and we have quite a big group of those folks that will note in the agenda record.
Thank you. Commissioner Lindley, we have quite a few requests for a contested case hearing in this matter, and our first task is to figure out which of those we should grant. Under Senate Bill 709, we can grant the requests of those persons who have timely submitted comments on relevant and material issues, who timely requested a hearing based on those issues, and who are affected persons, meaning persons who have a justiciable interest that is affected by the application and also different or not in common with those interests of the general public. And in addition, for associations to have standing, they must identify at least one member that has standing in his or her own right, among other requirements. And in my analysis, most of the requesters have failed to meet these requirements, but there are several who did meet the requirements. And what I thought I would do is start by identifying the ones who I think met the requirements, and then provide a few observations on those that fell short, and then maybe we can compare notes.
That sounds great.
Okay.
Thank you.
And I apologize for inevitably mispronouncing names, but I recommend that we grant a hearing to Becky Cox, Ruby Hartman, Liz James, Pamela Say, Douglas Harrison, Milan Guckian, Prue Guckian, Diane Higbee, Kenneth Higbee, Craig Johnson, Renee Wilson, the Heritage Oaks Property Owners Association, Stop 3009 Vulcan Quarry, and Friends of Dry Comal Creek. The remaining requests, in my view, failed to meet one or more of the Senate Bill 709 requirements, and let me provide a few examples of those.
Can I ask one quick question?
Yes.
Just on the names real quick, did you, they were just said fast, the only reason I'm clarifying. Douglas Harrison and Liz James, did you comment on those two?
Yeah, I'm
Okay.
recommending that we grant
Okay,
a hearing
great.
to them.
Thanks.
You want me to run through the list again? Okay.
That was it. Thank you.
So, tell you what, I think I read those quickly, so I know that you're up to speed, but for the benefit of the folks in the audience, let me slow down and read it again. So I'm recommending that we grant a hearing to Becky Cox, Ruby Hartman, Liz James, Pamela Say, Douglas Harrison, Milan Guckian, Prue Guckian, Diane Higbee, Kenneth Higbee, Craig Johnson, Renee Wilson, the Heritage Oaks Property Owners Association, Stop 3009 Vulcan Quarry, and Friends of Dry Comal Creek, and that we deny the requests of the remaining requesters. And so to provide a few observations on those that we denied, the Comal County Commissioners Eccleston and Haig, in my view, did not identify a personal justiciable interest that's different from the general public. Comal ISD failed to file any comments. The cities of Bulverde and New Braunfels are located far enough from the proposed plant that they would not experience effects different from the general public. And just to be clear, when I'm referring to the plant, I'm referring to the rock crusher plant, which is the subject of this application, and not to any broader boundaries such as property lines or the location of where a quarry may be sited. I'm recommending that we deny the request of the Bulverde Clean Air Stop Vulcan Facebook group because they failed to identify a member that has standing in her own right. And the same defect is true of the Greater Edwards Aquifer Alliance. In addition, the Alliance raised only water quality issues that are not relevant and material under the law governing this type of application. And there were similar deficiencies that thwarted the other requesters. So often the requests were based on issues that are outside TCEQ's jurisdiction, such as concerns about effects on property values, concerns about increased traffic and that sort of, those sorts of issues. So that is kind of my thinking on which requests pass the threshold and which do not.
That's what I had noted, so I would agree with, when we're ready to do a motion with granting a hearing to those people and parties that you named.
Right. Okay, for the issues, I'm going to recommend that we refer about 20 issues, and I have a list of those. Commissioner Lindley, what I might propose is rather than read them all to you and then have you
Yes.
read your list back to me in a motion, why don't we, when we're ready, go ahead with the motion. I'll just ask you to do what I failed to do, which is read slowly, and I'll cross-reference as we go, and if we need to dig into those issues and discuss them, we can do that. Does that work?
That works for me.
All right.
So if you're ready for a motion, I'll start.
Well, I think there were a couple of
wanna
requests for
discuss?
reconsideration,
Oh, I'm sorry, yes.
and I'm going to recommend that we deny both of those. One was not timely,
Mhm.
and the other one raised issues that were already answered by the executive director's response to comments. They didn't present new information. And I think a hearing duration of 180 days is appropriate for this matter.
I agree on all that. All I would add is that I appreciate all the hard work that's gone into this from all the parties, from the public, from the executive director, from OPIC, General Counsel's office, members of the legislature that were also involved. Sounds like where we're going, our intention is to send it to hearing, so it's not done yet. But I know this was a lot of work on a lot of people's part, and so I just want to acknowledge that. But I will start a motion if you're ready.
Yeah, thank you. And I'll just chime in on that too. Stakeholder participation is really important to what this agency does. And so let me just echo Commissioner Lindley's comments about the involvement of all
Yep.
parties. So, and thanks for the folks for being here this morning.
Yes, and
I'm ready to entertain a motion.
okay, here we go. Bear with me, it's rather longer. I move that the commission grant the hearing request of Becky Cox, Milan and Peru Gukian, apologize for any mispronunciation, Douglas Harrison, Ruby Hartman, Kenneth and Diane Higby, Liz James, Craig Johnson, Pamela Say, Renee Wilson, Friends of Dry, Kamal Creek, Stop 3009 Vulcan Quarry, and I believe this is the same property, or the homeowners association you're speaking about, but the Smithson Valley Heritage Oaks Property Owners Association?
Yes.
Is that, okay, just for clarification. That we deny the hearing requests and all the requests for reconsideration, and that we refer the matter to SOA for a contested case hearing on the following issues. A, whether the proposed plant will negatively affect human health, including sensitive subgroups and physical property. B, whether the conditions in the proposed permit will adequately protect against dust emissions from the proposed plant, including during periods of high winds. C, whether cumulative impacts of existing sources were properly considered. D, whether the controls in the proposed permit constitute best available control technologies. E, whether the proposed facility will adversely affect wildlife, vegetation, flora, and fauna. F, whether the proposed operating hours of the rock crusher ensure that there will be no adverse impacts to human health, welfare, and the environment. G, whether the air quality modeling conducted as part of the application adequately incorporated the local prevailing winds. H, whether the applicant complied with TCEQ's public notice requirements related to sign posting and newspaper notice. I, whether the proposed permit contains adequate monitoring and record-keeping requirements to ensure compliance with all applicable rules and requirements. J, whether emissions from on-site diesel engines are adequately calculated and adequately controlled. K, whether an adequate site review was conducted for this application. L, whether the background concentration used in the air dispersion modeling are representative of the proposed location of the plant. M, whether emissions from maintenance, startup, and shutdown activities are adequately addressed in the proposed permit. N, whether chemical dust suppressant is safe to use as a control for emissions from the proposed plant. O, whether emissions of silica from the proposed plant will negatively impact human health and welfare. P, whether the proposed permit conditions, including emissions limitations, are enforceable. Q, whether the permit application and associated air dispersion modeling included and properly evaluated all applicable emissions. R, whether site-specific monitoring data should have been used in the air dispersion modeling conducted for this application. And S, whether the applicant's compliant history precludes issuance of the draft permit or necessitates additional special conditions in the draft permit. And lastly, as you stated, specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
All right, that captures what I was had in mind as well, Commissioner Lindley. So the motion has been made. I second it. All those in favor?
Aye.
Aye. The motion carries. Thank you. Ms. Gross, why don't we take just a minute while people get situated to hear the next item?
That was the end of this one? Okay.
Yes, sir. That's the end of item 1.
I'll
Yeah.
put all the pressure on y'all to have a Merry Christmas.
Thank you all for being here.
There's a kangaroo somewhere. We'll see you again.
Thank you for being here. Ms. Gross?
Item number 2 is a Senate Bill 709, House Bill 801 hearing request concerning the application by Rio Grande LNG LLC for new air quality permit numbers 140792, PSD TX 1498, and GHG PSD TX 158. The parties have been notified that the commission will not take oral argument, but may ask questions, and this matter is before you.
Commissioner Lindley, these requests, like those in item 1, are also subject to Senate Bill 709. But in this case, I don't find that any requesters are impacted in a way that's different from the general public. This facility is demonstrated to be protective of public health and the environment at the fence line, and the requesters are all situated several miles from there. But I do want to qualify and comment on 2 of the requesters. The shrimpers and fishermen of the Rio Grande Valley have standing only to the extent that Ms. Burnell has standing. Ms. Burnell's residence and workplace are several miles from the proposed facility. The fact that she travels Highway 48 next to the proposed facility also doesn't distinguish her from the general public, and that conclusion is consistent with past commission actions. And because Ms. Burnell's standing is not established, because her interests are not distinguishable from the general public, the association can't have standing either. The other requester that I want to discuss is the city of Port Isabel. And while the proximity of the city's corporate limits and ETJ to the proposed facility would normally suggest that it may be affected in ways that differ from the general public, the nearest city-owned developed property, which is an animal shelter, is nearly 2 miles away, and there are no city residences near the facility. And more importantly, there can be no development within more than a mile of the proposed facility, and that prohibition is established by an easement deed that has been set up to establish and protect the Laguna Atascosa National Wildlife Refuge. So given this unusual permanent buffer, the traditional public health and welfare interests that can create affected person status for a city on behalf of its residents just isn't present here. And in addition, the economic and tourism-related concerns that the city cites don't differentiate it from members of the general public. At least that's how I'm viewing the matter, and I thought I'd pause to collect your thoughts.
I came to the same conclusions. The way you laid that out was great. I completely agree. And I would support a motion that denies the hearing requests and the requests for consideration.
Okay, I'll entertain a motion.
Okay. I move the commission deny the hearing request and request for reconsideration, grant new air quality permit numbers 140792, PSD TX 1498, and GHG PSD TX 158 to Rio Grande LNG LLC as recommended by the executive director, and adopt,
Sorry.
the ED's response to comments.
Thank you. The motion has been made. I second it. All those in favor?
Aye.
The motion carries. Thank you.
And for the last item, I failed to acknowledge that there are several individuals that signed in but did not wish to speak, and will note their presence for the record. Next up is items 3 through 24, which is the commission's enforcement docket. We have 2 individuals who, on items number 6 and 10, who have indicated that they are available for questions if the commission has questions, and program staff is approaching to lay these items out for you.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Janice Hernandez, and I am the Agenda Coordinator for the Litigation Division. With me today are Gitanjali Yadav, also of the Litigation Division, and Brian Sinclair and Melissa Cordell of the Enforcement Division, representing the Executive Director. Pending before your items 3 through 24. The total assessed administrative penalties are $494,696, with $104,175 deferred, $142,969 applied towards supplemental environmental projects, and $247,552 to the general revenue. The Executive Director respectfully requests approval of these items, and we're available to answer any questions you may have.
Thank you. And there were no requesters that wish to speak?
No.
Okay, thank you. Mr. McWhorter?
My office reviewed these items, and we recommend approval of the proposed orders.
Thank you. Commissioner Lindley, I've reviewed these items and think it's appropriate to move forward with approval.
I will, then I will move the commission adopt items 3 through 24 as recommended by the executive director.
The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. The motion carries.
Item number 25 is consideration of the monthly enforcement report, and we have enforcement staff here to lay this item out.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me is Brian Sinclair of the Enforcement Division and Gitanjali Yadav and Janice Hernandez of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2019 through October. There were 212 effective administrative orders issued, and of those, 32 contained supplemental environmental projects. These orders assessed a total of $2,029,878 in penalties, with a payable amount of $1,185,233. $479,148 are to be paid toward supplemental environmental projects. 2,384 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 235 enforcement action referrals have been received. There are 1,597 pending administrative orders, with 132 cases that are on the backlog. 222 cases are pending at the Attorney General's office for representation in district court, and no judgments have been issued. 2,149 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2017, 18, and 19. We are available to answer any questions you may have.
Commissioner Lindley, any questions?
No questions this time.
I don't either. Mr. McWhorter,
I didn't have any questions. Thanks for the report.
appreciate the report. Thank you.
Thanks.
Item number 27 is consideration of the adoption of amendments and repeals to 30 TAC chapters 35, 37, 50, 55. Oh, I'm sorry, I skipped one. I really apologize. Item number 26 is consideration for publication of and hearing on proposed amendments to 30 TAC chapter 342. And we have staff available to lay this item out.
Good morning.
Good morning, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I'm Laurie Fleet with the Water Quality Division. With me today is Michael Parr of the Environmental Law Division. The proposed rulemaking would amend 30 TAC Chapter 342, regulation of certain aggregate production operations, to implement changes to the Texas Water Code made by House Bill 2582 from the 85th Legislative Session. House Bill 2582 exempts entities from registration requirements in Texas Water Code Chapter 28A for sites where specialty or terrazzo-type stone is removed or extracted from the earth. The material is produced for commercial sale and used exclusively for decorative or artistic purposes, and the horizon that is exposed for current production does not exceed 5 acres. The proposed rulemaking would also replace regulated activities with extraction activities throughout the chapter and amend Section 342.25E for consistency with Texas Water Code Chapter 28A. The proposed rulemaking would add definitions for decorative or artistic uses, extraction activities, specialty stone, terrazzo-type stone, to improve understanding and enforceability. Staff respectfully request approval of publication of and hearing on the amendments to Chapter 342 and request permission to make non-substantive revisions to comply with Texas Register format. Thank you. We're available for any questions.
Thank you. Commissioner Lindley, any questions?
No questions.
Anybody signed in? No? Mr. McWhorter?
OPIC recommends approval for publication and hearing on the proposed amendments to the Commission's Chapter 342 rules to implement House Bill 2582.
Thank you.
Thanks.
Yeah, I agree. This is pretty straightforward rulemaking to implement legislation, providing narrow exemption, and I think it's appropriate that we move forward.
I agree. I move that the commission approve the publication of and hearing on the amendments to 30 Texas Administrative Code, Chapter 342, as recommended by the ED, including the revisions filed by the ED on December 10, 2018.
The motion has been made. I second it. All those in favor?
Aye.
Aye. The motion carries. Thank you. Now we can do item 27.
Now, item number 27. Consideration of the adoption of amendments and repeals to 30 Texas Administrative Code Chapters 35, 37, 50, 55, 80, 281, 290, 291, and 293. We have one individual who has asked to address the commission at the appropriate time.
Great. Good morning.
Emily Rogers.
Yeah, we'll let the ED.
Okay.
I'd ask staff to lay out the item, please.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Brian Dickey with the Water Supply Division. With me is Dean Tadema with the Environmental Law Division and Michelle Risco with the Water Supply Division. The adopted rulemaking would implement House Bill 1600 and Senate Bill 567 from the 83rd Texas Legislature 2013 regular session to amend requirements related to the transfer of the Utilities and Rates Program to the Public Utility Commission of Texas, implement House Bill 294 of the 85th Texas Legislature 2017 regular session to amend requirements related to appointment of a receiver to a water or sewer utility that has violated a final judgment issued by a district court in a suit brought by the Attorney General's office, implement Senate Bill 1842 from the 85th Texas Legislature 2017 regular session to amend requirements related to entities exempted from the requirements to file a business plan for a proposed public drinking water system, and implement staff proposed changes to facilitate the ability to convert the regulatory assessment fee from a self-report, self-pay fee to an online billed fee. The proposed rules were published in the July 13th, 2018 issue of the Texas Register. A public hearing was held on August 7th, 2018. The public comment period closed on August 13th, 2018. During the comment period, the commission received comments from Bickerstaff, Heath, Delgado, Acosta, LLP regarding Chapter 291. In response to the comment, language was added to 291.130D to clarify which elements in Texas Water Code 11.041A the commission has jurisdiction over. Staff respectively recommends adoption of this rulemaking to Chapters 35, emergency and temporary orders and permits, temporary suspension or amendments of permit conditions, Chapters 37, financial assurance, Chapter 50, action on applications and other authorizations, Chapters 55, request for reconsideration and contested case hearing, public comment, Chapter 80, contested case hearings, Chapters 281, application processing, Chapters 290, public drinking water, Chapter 291, utility regulations, and Chapters 293, water districts. Staff also respectively requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you. Commissioner Lindley, any questions?
Not this time.
I'd invite Emily Rogers to approach the podium. Good morning.
Good morning. Thank you all for letting me come and speak today. I'm Emily Rogers with Bickerstaff, Heath, Delgado, Acosta. I appreciate the opportunity to comment on these rules. Specifically, I'd like to address the changes, the proposed changes to Section 291, 130D. Bickerstaff had commented that as written, it was unclear what the TCEQ considered to be within its jurisdiction with respect to a Texas Water Code Section 11041 complaint. The changes that were proposed by the ED in this most recent version clarify that point, but incorrectly state what is within the Commission's jurisdiction. Section 11041 provides that a person who is entitled to water may file a petition with this agency if their water supply has been denied. There are two ways your water supply can be denied. One, a physical denial of the water, or two, your water supplier has demanded a rate that is so unjust and unreasonable, so high that you've effectively denied them water. The ED's proposed rule would eliminate from consideration whether or not the demanded rate was unjust and unreasonable. This is contrary to the plain reading of the statute, Section 11041, which requires this agency to render a decision on all of the elements of Section 11041. The determination of whether or not the demanded rate is unjust and unreasonable has not been transferred to the PUC. My recommendation would be to simply strike everything in Section 291, 130D after the first sentence of that section. I'm available for any questions.
Thank you. Any questions?
No. Thank you, Emily.
Appreciate your comments. Mr. McWhirter.
Good morning. I agree with Ms. Rogers' comments. Actually, my recommendation differs from the ED's only in that one respect, and I would also recommend not adopting the proposed changes to Rule 291, 130D that have been added since proposal was published. As Ms. Rogers described, the issue is the scope of jurisdiction in a hearing on a petition for denial of water under Texas Water Code 11.041. And the rule has been changed since publication to add subsections D, subparts 1 through 4 in an attempt to clarify, define, or limit the Commission's jurisdiction in accordance with the ED's view that the Commission no longer has jurisdiction to consider whether a price demanded of a petitioner is unjust, unreasonable, or discriminatory. Concerns have been raised about how to reconcile the authority transferred to PUC under Water Code Section 12.013 to fix a rate with the authority of TCEQ under Water Code 11.041 to determine whether the price demanded is just, reasonable, or discriminatory. As acknowledged in the response to comments, these questions are related, but they're not the same. Both Section 11.041 and Section 12.013 were amended by the legislature in 2013, so the assumption would be that the current express provisions of each statute can be harmonized. I understand there are practical concerns about staffing and other reasoning behind the ED's position about looking at these rates. However, I have concerns that the additional provisions of proposed Rule 291, 130D would limit the commission's jurisdiction in a way that does not track the exact language of Water Code 11.041. Again, I just echo the same concerns that Ms. Rogers expressed, and so for that reason, I would recommend not adopting those particular subsections, but in all other respects, I support adoption of the rulemaking as proposed by the ED.
Thank you. Commissioner Lindley, any questions?
No questions right now.
I'd like to ask staff for a response to Mr. McWhorter and Ms. Rogers' concerns.
For the record, my name is Dina Tadema. I'm representing the executive director. I'm a staff attorney. Well, the way the executive director looked at it was that we had to look at both 11.041 and 12.013. And when you look at the language in section 12.013, it says that the PUC shall fix reasonable rates for the furnishing of raw or treated water for any purpose in chapters 11 or 12. And then you have to harmonize that with chapter 11.041 and the 4 factors that are listed in there. The 4 factors, the concern that we had was with the 4th factor where it stated that the price or rental demanded for the available water is not reasonable and just or is discriminatory. And so when we look at that language, we believe that fixing the rate and determining what is just and reasonable are related questions which cannot be separated. In order to determine whether the price demanded is not reasonable and just, a determination of what the rate should be has to be made. And based on 12.013 language, that determination has to be made by the PUC and not the TCEQ. Therefore, we made the changes in 291-130 subsection D.
So I think it's a legal question what the effect of that language is, and the counter argument is that TCEQ retains some residual authority to make a finding on what a reasonable price is, just for the limited purpose of the denial of water petition process. And this is something that I sort of struggled with too, and I was hoping you could clarify things for me, Commissioner Lindley.
I can't. I struggled with it too, even walking over here, but just in my head. But kind of where I've come down on it is that it's my understanding there's probably going to be proposed legislation that touches on this topic next session. And I'm not sure it will fix everything or address everything, and it might address more things than we want it to. We never know what that's going to look like. But to kind of wait and see on that one, because if there's something that comes out of the legislature, that means we're going to be doing some sort of rulemaking addressing it then. And where I kind of come down on, I don't want to get it wrong, and it's hard. And so I also don't want to delay the rulemaking because we're up against the clock. And so I don't necessarily want to put off taking any action today. So I kind of want to move forward today with the motion of adopting what the ED's proposed, knowing that we will probably be talking about this issue again. And if something comes up, because rate issues are always before us, where this really becomes an issue that we need to address, then we need to initiate a rulemaking, which we could do. So I don't know if that's helpful or not, but that's kind of where I am right now.
Yeah, it is. Let me just provide some more thoughts on kind of the totality of the rule package in front of us, and then maybe we can talk a little bit more about path forward on the matter before us. So this rulemaking package implements not only the legislation that transfers the economic regulation to PUC, but also a couple of other unrelated pieces of legislation that deal with receiverships and business plan requirements for public drinking water systems. And unlike the last rulemaking package, this one is not so straightforward. It's big. It touches a lot of chapters. And I'm satisfied that the rule package is appropriate and accomplishes what it sets out to accomplish, with actually 2 reservations. One is the one that we've been discussing around the petitions for denial of water, and the other has to do with our how we allocate authority between TCEQ and PUC for issuing emergency orders. And I think we've pretty well work through, at least at a high level, what the concerns are on the denial of water petitions. Let me talk a little bit about emergency orders and my view of that issue. What this rulemaking does is it interprets the legislation to transfer all authority for certain emergency orders to the PUC, and there's a disagreement among the agency's lawyers about whether this is the best interpretation. I think my view is that the interpretation that we're adopting in this rulemaking is at least a reasonable interpretation, but there are legitimate concerns about whether it might leave a gap in enforcement authority, particularly given the expertise and resources of PUC that would be charged in this view of the world with issuing those orders. So I'm sensitive to that. At the same time, if TCEQ were to issue an order, and specifically I'm talking about orders to provide interconnections and to provide continuous service, if TCEQ were to issue such an order, I think it could be vulnerable to a challenge that TCEQ lacks the statutory authority to issue that order. So we're sort of stuck either way. So bottom line is we have some work to do. We need to reconcile and harmonize the big policy idea, which is to transfer economic regulation to the PUC with the statutory language and with how these two agencies implement the legislation, in ways that are effective, efficient, and practical. And I don't think anything we can do here from the dais today that will achieve that, and I suspect it will require some statutory changes. So I think that's where we stand. And heading in here today, I was going to propose that we go ahead with this rule package and let the bulk of it that's accomplishes what it sets out to accomplish take effect, and then continue our work with PUC to find solutions to the legitimate concerns. I have some hesitation about that around this issue on the denial of water petitions, because I'm very sensitive to the arguments that Mr. McWhorter and Ms. Rogers outlined. So let me pause there before I suggest anything, just gauge your reaction to all of that.
I agree, and I appreciate the executive director's proposed preamble language, where it simply says that the commission acknowledges that PUC and TCEQ share dual jurisdiction over some issues and intends to coordinate closely with PUC. At the end of the day, both of our agencies are going to step up if an emergency situation comes up. I don't believe we're going to let the health and safety of people get caught up in this kind of minutia. I would hope we wouldn't. I mean, both agencies, I don't think we'll let that happen. And so for those reasons, I'm comfortable moving forward with today as well. I also share the same concern that if our commission was to issue an emergency order under 13.041, that it would likely not withstand a legal challenge, which you kind of touched on as well. And I want to be very cognizant of that, because I don't want to get this commission into a bad space or a bad place. As far as the comment we received today and in the record, I don't have, I agree with you. I'll just say it that way. I'm very sensitive of what we might be doing, which is putting someone in a petitioner in a difficult situation. It's just a tough legal issue, and I would hope that we could get it clarified some way, but that's not for us to clarify. I do think that's probably something best clarified by the legislature. I'll pause there.
Okay. Well, I have at least one idea about how to move forward, but I think I want a short sidebar with our council to think through these issues. Odd. I'm ready to continue if you are.
Yes, I'm,
Okay. So experts, two reservations about this rulemaking package. One was on the petitions for denial of water, the other on the allocation of authority to issue emergency orders. And as to the second issue, I'm comfortable that what underpins this rulemaking is at least a reasonable interpretation of the statute. I think it probably needs to be revisited as we continue our conversations with PUC about how best to implement the legislative policy. The first reservation about hearings, proceedings on petitions for denial of water, I'm not so comfortable with the legal interpretation that underpins the rulemaking. I'm sympathetic and candidly agree with Ms. Rogers and Mr. McWhorter's assessment of how that language stacks up against the statute. And council suggested that we could draft a motion that sort of surgically strikes that language, reverts back to the rule on that issue as proposed, and we could kind of proceed accordingly. And I think that would be my recommendation at this point.
that, I would agree if you have a motion,
Okay.
might be better said by you.
Yeah, great. Well, council is drafting a motion,
Okay.
so let's just take a few more minutes and let him finish writing and give me a chance to review it, and then I will make the motion.
Thank you.
Thanks.
Great.
Commissioner, I have a motion.
I'm all ears.
I move that we adopt the proposed amendments to repeal of 30 Texas Administrative Code Chapters 35, 37, 50, 55, 80, 281, 290, 291, and 293 as recommended by the Executive Director, except not adopt the additional rule language proposed at adoption to 30 Texas Administrative Code 291.130D, but include the revised preamble language for 30 Texas Administrative Code 291.14 and 291.114.
I second.
The motion has been made and seconded. All those in favor?
Aye.
Aye. The motion carries.
Just
Thank
to-
you.
Just to clarify on that last motion, proposed amendments and repeals is the,
Yes.
I think I said that. Yeah.
Yes, that's what I support, amendments and repeals.
Repeals, but I think I did say both.
Item number 28 is consideration for publication of and hearing on the proposed Dallas-Fort Worth redesignation request and maintenance plan, state implementation plan revision for the 1 hour and 1997 8-hour ozone national ambient air quality standards. We have staff staff arriving to present this item. We also have Ms. Shayna Joyce with Texoga, if the commission has questions on this or the following item.
Good morning.
Good morning, Commissioners, General Counsel, Public Interest Counsel. I'm Kathy Singleton of the Air Quality Division. With me is Terry Salem of the Environmental Law Division. For your consideration today is item number 28. The Executive Director's recommended Dallas-Fort Worth redesignation request and maintenance plan supervision for the 1 hour and 1997 8-hour ozone national ambient air quality standards. This supervision would include a request that the EPA redesignate the DFW area to attainment for the 1 hour and the 1997 8-hour ozone standards, and would provide a maintenance plan that will ensure the area continues to meet those standards through 2032. The supervision would also include a contingency plan and would establish motor vehicle emissions budgets for the 2032 horizon year. Staff respectfully requests permission to publish the proposed supervision, solicit public comment, and hold a public hearing. Thank you for your consideration. We're available to answer any questions.
Thank you. Any questions?
No questions.
Mr. McWhirter?
OPIC recommends approval for publication of and hearing on the proposed DFW redesignation request and maintenance plan supervision for the 1 hour and 1997 8-hour ozone national ambient air quality standards as presented by the Executive Director.
And I agree. This is similar to the proposals we recently made for the Houston, Galveston, Brazoria, and Beaumont, Port Arthur areas. And I think following the South Coast opinion, it's important that we move ahead to provide certainty around attainment status for DFW. So I think we should go ahead
I agree. I move that the commission approve the publication of and hearing on the proposed Dallas-Fort Worth redesignation request and maintenance plan, state implementation plan revision for the 1 hour and 1997 8-hour ozone national ambient air quality standards as recommended by the Executive Director.
The motion has been made. I second it. All those in favor?
Aye.
The motion carries. Thank you.
Item 29 is consideration of the adoption of the Houston, Galveston, Brazoria redesignation request and maintenance plan, state implementation plan revision for the 1 hour and 1997 8-hour ozone national ambient air quality standards, and we have staff here to present this matter.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. My name is Lola Brown. I'm with the Air Quality Division, and with me today is John Minter of the Environmental Law Division. For your consideration today is item number 29, the Houston, Galveston, Brazoria redesignation request and maintenance plan SIP revision for the 1 hour and the 1997 8-hour ozone national ambient air quality standards. This SIP revision includes a request that the EPA redesignate the HGB area to attainment for the 1 hour and the 1997 8-hour ozone standards, and provides a maintenance plan that will ensure the area continues to meet both those standards through 2032. This SIP revision also includes a contingency plan and establishes motor vehicle emissions budgets for the 2032 horizon year. Public comments received during the comment period have been addressed and summarized in the SIP revision. Staff respectfully requests adoption of the SIP revision and are available to answer any questions. Thank you for your consideration.
Thank you. Commissioner Lindley, do you have any questions?
No questions this time.
Mr. McWhorter?
OPIC supports adoption of the Houston-Galveston-Brazoria redesignation request and maintenance plan SIP revision for the 1 hour and 1997 8-hour ozone national ambient air quality standards as presented by the Executive Director.
I do too, and I've mentioned this before, it's not a new development, but Texas has made great strides in reducing ground level ozone concentrations statewide, including the Houston-Galveston-Brazoria area, and that's really truly cause to celebrate. The Houston-Galveston-Brazoria area has been in attainment, has monitored attainment with the 1 hour ozone NAC since 2013 and the 1997 ozone NAC since 2014, so we have nearly approaching a half a decade of monitored attainment of those standards, and again, that's cause to celebrate. So I think it is time that we redesignate the areas to attainment. And of course, we still have work to do. We have the 2008, 2015 standards that we remain focused on. But this time, I think what I'm getting at is I think we should go ahead and adopt this redesignation and SIP revision.
I agree. Well said. So I will move that the commission adopt the Houston-Galveston-Brazoria redesignation request and maintenance plan, state implementation plan revision for the 1 hour and 1997 8-hour ozone national ambient air quality standards as recommended by the Executive Director.
The motion has been made. I second it. All those in favor?
Aye.
Aye. The motion carries. Thank you.
Item number 30 is the public comment session. I do not currently have anyone that is signed in to speak. So that takes us.
I have a comment.
Okay.
So this is Tracy. Thank you for being up here, and I want to thank Todd and Elaine for taking turns as our acting general counsel. Also, for those of you who weren't here at our last session, which was strictly an executive session, and other than the clerk, the commissioner, and our videographer, there was nobody here, but we announced that we hired really an outstanding lawyer from the Attorney General's office to take over the position of General Counsel, and I'm very excited to welcome Mary Smith to the agency beginning January 1 or January 2. And again, I want to thank all of our General Counsel's office for doing double duty while we were working without an official general counsel, and particularly for those who took turns sitting up here on the dais with us. So thank you for that, and look forward to seeing a new face in the new year. Here endeth my comment.
The commission will not be meeting in closed session today.
The time is 10:25. We are adjourned.